recording in progress. So, so nice to have you revisit us, Tom. And already,
Thank you.
already on the line is Joanne Woodson, who Ashley, is going to lead the interview on. And Joanne has so much interesting things to say. I don't know if we've overextended ourselves today, but we'll do the best we can. Thank you, everybody. Let's kind of jump right into it. So you probably could see us all anyways. So here's Tom, Ashley, and myself. We'll see more of Joanne in just a little bit. What's our agenda today? Not exactly what went out in the email notification, but pretty close. We're going to start off, we're going to talk about 2 cases, city ban on short-term rentals, and that's really unenforceable without Coastal Commission approval. And then a landowner's duty to basically provide adequate guest parking, and we'll talk about that. Then we're going to have our wonderful interview with Joanne. Like I say, she has so much to say. Joanne is such an interesting person. That's going to be really great. So I hope you stay with us. And then after that, we have a couple more cases. One, which is, what does the word "or" mean when it is in a document that was created? I know I deal with that all the time in my work life for the California Association of Realtors in creating forms. And I bet a lot of you out there, when you're creating real estate documents, transactional documents, you try to decide, do you put an "or"? Do you put an "and"? A lot of people put "and/or," which I hate, but we'll talk a little about that and how the cases have looked at it. And then we're going to talk about what's really a taking case, a case where a developer was required, if they wanted to do their development, to have to pay for all the future improvements that might be needed, not just from traffic that's caused by their development, but other developments as well. So we'll see what an appellate court has to say about that. And then we'll jump into some upcoming events. Glad Tom is here, because Tom's going to talk about an annual event that he puts on called the Crocker Symposium. And of course, we'll ask you what you think we should be doing. And that leads us into our first case of the day. All right, so here we have Crack versus Santa Barbara, and we'll just go through some of the basic facts here. In 2015, City of Santa Barbara began regulating short-term vacation rentals, essentially treating them the same as hotels, motels, etc., provided revenue to the city, but essentially the way the regulation or the way the ordinance was drafted essentially prohibited short-term vacation rentals, STVRs. There was a plaintiff in Santa Barbara who was a manager of short-term vacation rentals and brought a legal action challenging the ordinance. Once the challenge began, what happened? The California Coastal Commission sent out letters, not just to the city, but to others in the state as well, saying, hey, wait a minute, you can't have this kind of prohibition without seeking approval from the California Coastal Commission. The plaintiff, the manager, brought a writ of mandate seeking to enjoin the city from enforcing the ordinance without first receiving Coastal Commission approval. Okay. And the trial court issued the writ of mandate. So what's really the law here? By the way, something I didn't mention, which is prior to 2015, Santa Barbara basically, like I say, they allowed these types of rentals, but it was really insignificant, right? Concerning what was happening in their city. But I think, as everyone knows, really in the last 10 years, through Airbnb and VRBO, there's just been an increase, a flood of short-term vacation rentals, much to the dissatisfaction, quite honestly, of a lot of residents who live in these areas, particular coastal areas. We see a lot of dissatisfaction, and we see a lot of cities that attempt to impose restrictions on short-term vacation rentals. So the court here, the appellate court, was looking at the law, went back, said, hey, wait a minute, the Coastal Act of 1976 requires a permit for any development, okay? And the issue is, well, what is a development? And a development is defined through case law as any change in density or use. A development does not have to be an actual physical restriction or a physical impediment or a physical alteration of any kind. And so what the appellate court say, they said, well, guess what? The ban on short-term rentals in the coastal zone, so not for the whole city, only that part of the city that is in the coastal zone, constitutes a development under the Coastal Act and required either a permit or an amendment to the local coastal program, which requires coastal commission approval. And when I put down here, there's a related decision that's actually cited in the Santa Barbara case, where there was a restriction brought by a homeowner association that was also struck down by a challenge was brought by an owner of property in that association who thought that it violated the Coastal Commission Act, and lo and behold, so there was a related decision. I know, Ashley, you had, I think maybe it was last month or the month before, you had talked a little bit about, or you had mentioned maybe something about the HOA prohibition. Well, this is extended further, right? This case really solidifies something that everybody is probably already aware of, which is, hey, guess what? You know, the federal government, their rules can supersede states. The states can supersede cities, right? Cities can supersede HOAs. So everybody has to comply with the next higher up in authority. And that's kind of what happened here. Those people who believe in local control are not going to be too happy with this decision. Those people who like essentially higher authority preemption, maybe they'll like it. Tom, any comments on this case?
Yeah, I've been speaking on short-term rental laws for years now. I first started doing these presentations, I want to say in 2015 or 16. So I've definitely tracked what all these cities are doing and where things have changed. And I actually did a presentation in Santa Barbara on this a couple of years ago. And they were very unique in that they were not allowing short-term rentals in any capacity, whereas every other city that's enacted ordinances has had some sort of regulation or restriction on the number or the days or whatever. But Santa Barbara was unique because they had a complete ban. So I'm not surprised that this challenge came against the city based on the Greenfield case, because that Greenfield case was a huge monumental case for homeowners associations and not being able to enact restrictions for short-term rentals going forward. So yeah, when you sent me this case, Neil, I was like, yeah, that's pretty much on point with what Greenfield decided. So it's interesting.
I find it interesting too, because it involves essentially preempts a restriction, and it, I think, achieves a policy directive of the coastal access, right? So I mean, from just the policy standpoint, it's interesting because, like, why is it in the Coastal Commission's interest to actually step into this case?
Mm-hmm.
You know, and that, you know, I mean, they're obviously enforcing their jurisdiction, but it is interesting because the end result is it facilitates, you know, public access to coastline.
Yeah, and the Coastal Commission was involved in this case. They did submit a brief. I think it was as an amicus. So obviously they were very interested in the outcome. And, you know, like all laws, right, there needs to be some kind of balance. And it's interesting because the city that you would think is responding to the wishes or the desires of their constituents, in other words, the residents in the city, saying, this has gotten out of hand. You know, we thought we were buying into some kind of close, maybe quiet community. And at least in some areas, you hear about just an influx, you know, of people that are, I'm sure this is not always the case, but the ones that you hear about where people aren't really respecting the laws and not respecting the privacy of others. And so those constituents complained right to their representatives at the city level. And the Coastal Commission is basically a state entity that was set up and saying, well, wait a minute, our interest of the whole state supersede those of the community that's being directly impacted there. So anyways, thought that was an interesting case. Thought we'd share that with you. If you don't have any comments, I'll go on to our next one. No more? Okay, great. So I found this case really kind of interesting, and there's a really nice discussion in this case. So a really well-written opinion that goes through the law. And when I get down to that section, I'll tell you a little bit about that. First, let me just read through some of these facts here. You have a pedestrian who parks along a 5-lane highway, then jaywalks across the road because they didn't want to walk, I don't know, 100 or 150 feet to where there was actually a crosswalk. I can't remember if there was a light there at that spot or not. Why? Because they're visiting somebody in a condo complex that is on the other side of the street. Before the person parked across the highway, they looked for a spot in the complex, could not find a spot, said, forget it, I'll just go, park outside the complex and walk. Lo and behold, it was at night, they're crossing, I don't know if this is normally a busy, but if it's 5 lanes, it's probably kind of a busy thoroughfare. And unfortunately, they were hit by a car and seriously injured. So what did that person do? They sued the condo complex for negligence and premise liability under the theory that they did not have enough guest parking. When the development was approved, the city or county, I can't remember which, required a certain number of parking spaces. The complex actually met the minimum number of parking places overall, but had fewer visitor spaces than were required. In this case, the plaintiff brought their suit. The trial court granted summary judgment for the condo complex, saying there is just no duty of law to them to protect a visitor from harm by crossing a public street. The court went into a really nice discussion, quite honestly, of what a duty of care is, that one person has a legal duty to prevent harm to another. Many of you probably remember Rowland versus Christian from your law school days. If you went to, or if you of course read about Rowland versus Christian, and of course that takes everybody back to what? The famous Hallsgraf case, right? Which is it foreseeable that there will be harm? And like I say, a really nice discussion in this case by the appellate court justices of what the law is. They cited existing case law dealing with the duty of a homeowner to somebody crossing into the homeowner's property. And one of the cases they cited was where the complex actually had a parking lot across the street. I know actually probably just 2 miles away from where I live, there is, I guess, what would now be called a mega church. And it's on a pretty busy thoroughfare where I live. Across the street from this church, they now have 2 huge parking lots. But in order to get to the church for services, nobody goes to the stoplight, half a block away. Everybody just crosses that busy street. I've seen in this particular church, like I say, near where I live, they actually have guards. They have crossing guards to help people get across. But case law said basically, even if you have an offsite parking lot, there's no responsibility to visitors or invitees that are crossing over the public thoroughfare to get to your site. So I thought it was an interesting decision. It's good for people who want to read up, get a kind of a little reminder of the law. And I'll turn it over to Ashley, Tom, and Joanne if she feels like joining in.
I would have been shocked. I would have been shocked if the HOA was responsible in this situation. I mean, that'd be the same as if someone left a football game and crossed a street from the parking lot of the stadium and got hit, like why would the stadium or the parking company be responsible for that person not looking where they're going and crossing on a busy street where they're not supposed to?
Yeah, I look at this and I think, well, one key fact is this person was jaywalking, so it made the analysis easier. I think the analysis still would have come out probably the same if they were, crossing the street legally, but you have a right, I think, to assume if you're the owner of the complex that anybody, that people conduct themselves in a lawful manner, and in this case, they conducted themselves, that although a minor crime, but that I'm guilty of myself. But I think it made it easier for the court to render its decision on this. You just have a right. You have a right to assume under the law that other people are not going to behave negligently or illegally.
And when the court here was talking about the common law duty from the homeowner association, really, to the visitor, they were saying there's just too many intervening factors to say that it was foreseeable. Like you say, the person was jaywalking rather than walking a little bit further to go to a better place to cross. Not only you can have somebody jaywalking and maybe everyone's going really slow at that particular point in time, right? Or is there a difference between somebody who's crossing at night and somebody crossing during the day? So the court said, it was not foreseeable. There's just too many bad things that had to happen in order to find common law liability. So I agree with you, Ashley. I would have been surprised on that issue if it came out the other way. I was a little more, I guess I was not, I'm trying to think how to say this. I was a little more surprised, I guess, when the court addressed the issue of the fact that the association did not have the required number of visitor spaces. Because now you have something in place, right? You have a city or a county that's telling this landowner, you need to have a certain amount. So essentially I thought the court could say that through that development requirement, that a public policy was being established. And since it was a violation of the public policy, I thought there might be liability on the grounds since the association did not comply with the required number of visitor spaces. And it was kind of interesting that when the court reached that issue in the opinion, they said, well, the purpose of having visitor spaces was not to protect visitors, but was to protect the aesthetics of the homeowner association. And that's kind of what they hung their hat on to stay with the common law theory. So like I said, I was a little bit surprised about that, about how easily the court dismissed the reason for having visitor spaces, but you get what you get in court, right?
Tom, since you do litigation, do you think it would have been different if it had been an owner space and there weren't enough owner spaces and the owner couldn't park in the complex where he lives?
Well, I mean, to me, the thing is if there were additional space, it's funny because I agree with Neil. It's interesting how they just said it was for aesthetic purposes, but you can also argue a foreseeability issue, right? Because let's assume that there were more spaces. Who's to say? It's conjecture whether or not there would have been vehicles in those spaces anyway. Like, who's to say that when this individual arrived, that there would have been, had there been an additional space, it could have been taken by anyone. Mm-hmm. So it's an interesting issue.
And that kind of goes along with what Ashley was saying, which is, well, wait a minute, if there was more visitor spaces, that means there would have been less spaces for the owners in the complex. And that means, would you be forcing owners to park on the street or across the street? And who's going to be more likely to be accessing the property, an owner or the occasional visitor or invitee? So a tough issue all around. Okay, well, thanks for that discussion, guys. Let's go into, gonna turn it over to Ashley and Joanne. Unmute yourself because we're gonna find out all about you and your company and some very interesting things that you have going on.
All right, thanks, Neil. So Joanne is one of my favorite people and a commercial leasing guru up in the Bay Area. So Joanne, why don't you introduce yourself a little bit and tell us what you do, so for those that don't know you.
Okay, nice to meet everyone virtually. My name's Joanne, as Ashley said, and Ashley also one of my favorite people. I am a solo practitioner. I've had my own solo practice for the past 5 years, and my area of expertise is commercial leasing. And I have been often called a leasing diva because I only do commercial leasing, which many of my attorney friends like because they get lots of referrals. Because if it crosses my threshold and it's not commercial leasing, I don't do it. I don't touch it. I give it to other people. So I have a mix of clients from, I just finished a little comic book store lease in the Mission in San Francisco, which was a fun little lease to do. I have artisanal coffee roasters in San Francisco. And then on the other hand, I have very large high-tech tenant clients who take down tens of thousands of square feet of office space at any given moment, as well as industrial clients. I have a spice client. So, you know, they import spices and prepare them for sale, as well as I have landlord clients, and they range from a couple who might just have one investment property as sort of their retirement property that they lease, to large institutional landlords with multiple office, industrial, retail properties. So it kind of runs the gamut. I'm very lucky. I really enjoy my clients, and I really love commercial leasing. So that's me in a nutshell.
You know, Joanne, can I ask a question before Ashley gets into the heart and soul there?
Sure.
I'm just curious where your clients are located. You mentioned San Francisco. Is that the bulk of your clientele? Do you do all of California? Do you spread out?
I do all of California, and I'm also licensed in Nevada.
Okay.
But I've worked in the Bay Area basically for the past 35 years or so. So most of my clients are in the Bay Area, but I have clients throughout the state of California, and I have just started doing some leasing where my California clients have purchased property in Nevada. And so helping them with their leasing in Nevada as well.
That's actually good to know. I completely forgot you were licensed in Nevada, because I sometimes get some clients with property stuff in Nevada that I don't touch. So now I'm going to remember that.
Now you have local counsel.
Yes. So remind me how long you've been involved with the real property section, Joanne?
Gosh, must be about 5 or 6 years at this point.
So Joanne is now an advisor role, but was on the Real Property Executive Committee as a voting member for 3 years plus. And
during that difficult time when we split off from the state bar. So it was a very exciting time to be on the XCOM.
Yes, that was pretty much when I first came on, was right after that had happened. And I was like, what did I get myself into?
Yeah.
But one of the things that you really headed up through the real property section was this Women in Leasing series. Do you want to talk about that a little bit?
Sure. So I founded the Women in Leasing Law series about 7 years ago. And the reason I did it was because about 10 years ago, I started really attending conferences and starting to try and market myself. This is back when I was at a law firm. And the first real property law conference I attended, which then was called the Annual Retreat, I think the statistics were something like 80% of the speakers were male, and most of them were older white males. And so I was trying to figure out why aren't, women are 50% of lawyers, even back 10 years ago, why aren't more women speakers? I was negotiating plenty of leases with women lawyers. I have plenty of women clients, and there are plenty of women brokers. Now, statistically, brokers, not as many as men, but still, I knew plenty. And what I realized is that there was sort of a self-defeating process where many women professionals in commercial real estate were intimidated about putting themselves forward to be speakers. That there was a wealth of talent out there, but they were intimidated about applying for an annual conference at the state level. So I started the Women in Leasing Law Symposium as a way to encourage women to become speakers in, quote unquote, a safe and supportive environment where they would be speaking for their first big speech in front of a friendly audience who would provide them with support and constructive feedback, etc. And that has just really taken off. The first year I did it, I sort of was honoring the women in commercial brokerage community. And so we had a panel that ranged the gamut from a woman who was the first commercial real estate broker in San Francisco to a younger woman, probably early 30s, who had just started her own brokerage firm, and in between. And it was just fabulous. And part of it is raising awareness of women as commercial real estate professionals, that there are a lot of us. And then we've had programs every year since then: work letters, security deposits, letters of credit, mechanics liens, COVID. Last year, our program was COVID. We did 3 panels virtually on COVID and leasing, which was, just staying on top of developments in leasing right now is really hard because of COVID. And so we've just sort of banded together, and that was really successful. And then we just finished up a virtual program in the last 2 weeks. One was on lease workouts. So this was sort of post-COVID, we hope. How are leases being restructured, existing leases? What are the tips and strategies for landlords and tenants in those negotiations? And then we had an assignment in subletting, because, as I'm sure most people know, subletting is huge right now in every single US market. Basically, there is a glut of sublease space on the market. So certainly my practice is probably about 50% subleases right now. And so we thought it'd be good to have a refresher on the elements of sublease and assignment. And then we had a session on guarantees by foreign entities, something that is very strange and weird to your average lawyer. Like, how do you enforce them? Are there special provisions that should be in the guarantee? And all these programs have been recorded and are in the law library. So if people missed them, they can have the opportunity to, at some point, go in and watch them. So it's been great. And the rewarding part of it for me has been to see women then take off and go on to speak at state level conferences, to become active in the real property laws section at the California lawyer level, state level, and to go on and do their own marketing based on a talk that they gave initially as part of the Women in Leasing Laws area. So it's been really, really great.
You've been such an integral part in getting women speakers at any of our seminars or panels or whatever. So it's been really phenomenal what you've done, Joanne, and with that series becoming as popular and as annual recurring signature event for the real property section. So congrats on that.
So one of the speakers last week, what we do is we often pair a person who hasn't had a lot of speaking experience with a person who has some. And so the older person can, not necessarily older, but just more experienced, can mentor that newer person. And this was a young partner, actually, in a firm who had never spoken before, was very anxious about speaking, did a fantastic job. And then I was in a meeting with her the week after, and this is a woman I've been in meetings with once a month for the past 14 months, who barely has said a word. And all of a sudden she's speaking up, because she'd had this successful experience. She's like, oh, I'm a valuable person. I have things to contribute. And so that was so great. That was so great.
I know how that feels though. Like when I was first starting to do speaking events, I was just like, who would want to hear what I have to say? I'm so new, like I don't know that much, why would someone take advantage, take what I have to say for face value? And that was something that was really hard to overcome as a new attorney, and not being as experienced and still wanting to speak on these panels and talk about things that I do. So I get that. And it's super helpful to learn to speak in public.
Oh, absolutely. And it raises your profile in your law firm. If you're in a law firm, you can, let your other colleagues, if you're trying to become a partner, let your partners know, hey, I gave this big talk. It was very well received. You could even take that same talk, and I've had people do this, and give it inside your firm. Say, okay, I just gave this talk for MCLE credit, so I could give it within the firm for MCLE credit, and then you get a chance to shine in front of the people who are going to give you raises and promote you. So there's all sorts of ways that this can be. You can take that same talk and give it to clients. I've done that many times. Say, hey, client, especially during COVID when there was hardly any work, I would say to a client, hey, I gave a talk on assignment and subleasing. I'm happy to sort of give you the nuts and bolts of that in a free Zoom call. And I've had clients take me up on that, and it really helps solidify client relationships. And you've already done all the work because you already gave it somewhere else. So it's not that much to take an hour of your time, and the clients love it. They love getting stuff for free.
Joanne, I want to tell you that it's good for the speakers. I'll let you know, I've had the privilege of attending one of your events that was live and another one virtually. And it's good for the audience as well, because when you're listening to, you get really quality people to speak at your events. And it's really good to hear the different perspectives. So it's good for the speakers. It's also good for the audience.
Right. There is that fact that for many in the audience, they may not have seen a panel of all women commercial real estate professionals speaking before. And so just to have that sort of, even if it's semi-conscious, moment of wokeness. Oh, look at all these women and how competent. And boy, they're telling me a lot of stuff I hadn't thought about before. This is really great. So yeah, absolutely.
And I've also had the privilege of attending a live event up in San Francisco with you, Joanne, and you moderated, and it was really nice because I love the way that you facilitated the discussions. I just frankly, you can tell from the way that you participate in these panels how much of a passion you have for basically, putting on these events and helping promote the panelists and the volunteers who come and try and get their feet wet in commercial leasing, getting that exposure. So it's just wonderful. And I think that for anybody who hasn't attended one of Joanne's events, it's something not to be missed.
Definitely. And so something super cool about Joanne that most of us didn't know until recently is that she just became licensed as a solicitor in England. So tell us what made you decide to do that, Joanne, and why, as if practicing law in California wasn't enough.
Well, and Nevada.
And Nevada, yes.
It's interesting, and it's funny. Life has got funny old tricks, doesn't it? So I was, as I think a number of the people on the call today are, I lived through the 2008 Great Recession, and before that, the dot-com burst. And so I was familiar with the fact that real estate especially has cycles where you have a lot of work, you don't have much work. And as a solo practitioner, I was trying to think, well, what can I do so that I have another skill set? So when there's the next downturn, I will have this other skill set to draw on. And as I mentioned, leasing diva, not going to learn anything else except leasing. At the same time, not a lot, but sometimes I've been asked to look at leases for my clients in other countries. And I had always been really interested in that. I always, of course, work with local counsel. And I'm like the liaison between my client and local counsel. I know my client, I know what they want, I know their concerns, and I spend the time to kind of help translate how the leasing works in this other country and how it works in the US to help them understand. And so I just love England. Been to England many times, wanted to learn more. I have a client who has a lot of high tech startups. They have offices all over, but especially in Europe. And I thought it would be interesting to qualify there and then be able to help them with their leasing in England. So that was the impetus for it. And it took a couple of years. The law has changed now, but at the time I started this process, there was a way for foreign lawyers to take a series of exams to qualify as a solicitor. The first exam is a one-day long multiple choice test, and that's offered all over the world, including a couple testing sites in the US. And then the next series of exams is a combination of oral and research which takes place over 6 days, 6 half days, over 2 weeks, and it only can be taken in London. And there are, fortunately, Bar Bree courses that can help prepare you for this, that include a live tutor who helps give you mock exams, because, like I said, part of this is oral presentations. It was very interesting to see how another country does their bar exam, because of course at least I don't know of any state that has an oral argument component of their bar exam. And so they also really emphasize client relationships. So 1 or 2 of the components of the oral exam will be you're presented with a pretend client who's an actor that's hired for the purpose. And you're given like 10 minutes to review a fact scenario. So it could be they're buying property. It could be they want you to represent them in the bail hearing. So you're given the facts and you have to interview the client. And so part of what you're evaluated on is how well you interview the client and how well you explain the law to the client. And of course, there's nothing like that in the US. And I think it would be good if we had something like that. Because I think when you go to law school, I mean, it's changing, but unless you're in one of the clinical programs, I don't think there's a lot of time spent, and it's mostly in the criminal context, time spent on how to talk to a client, how to explain the law to the client. And that's something you develop over time as a practitioner, but something I think would be great if law students could be exposed to. So anyway, that took a couple of years. And then I was in London during lockdown in November. I was supposed to take it last April, but no travel at that time. So I had to go in November, self-quarantine for 2 weeks. And then London went into lockdown a couple of days after I got there. So basically for a month, I went to the grocery store in London. And that was all the touristing I could do besides taking my exams. And then, it takes them months because of all the oral components to let you know. So in the spring, I found out. And then you have to do an FBI check and all this other junk. So finally, a couple weeks ago, I got the word that I had been admitted.
So Joanne, we only have a couple more minutes left, with your interview.
Sure.
Do you want to mention your commercial leasing program before we need to move on to other parts of our
Sure.
presentation?
So 2 things I'll mention super quick. One is that our next Women in Leasing Law, we'll have an annual conference of some kind next year. Who knows, virtual, real, what it's going to be. Time will tell. But we're launching a multi-year virtual series on international leasing, where a local US attorney will be paired with a practitioner in that country. So it could be Spain, Japan, China, England, Poland, and we'll give a 1-hour MCLE, just giving you sort of like the basics of what leasing in that country is and how it's different from the US. So in some countries, for instance, you have to register a lease. In some countries, you have to pay taxes on leases. And this is not to make the US attorney an expert. It's to have these in the vault, so to speak, the Real Property Law webinar vault, so that if a client ever calls you and say, oh, I have a lease in Poland, you'd be, oh, let me see if they've done a presentation. Then you can sound a little less like an idiot when you talk to your client. And then the second thing is, I've done 1 million of these MCLE webinars, which I love. I go to 1 million conferences on leasing, International Council of Shopping Centers. I go to the Advanced Leasing Institute, which is by invitation only in Georgetown every year. And the problem with these great and Real Property Law Conference we've been talking about, our multi-day conference is something that is viable in the future. People are so busy, especially now with COVID. We're like, oh, you can get all this online. Why go somewhere and spend all the money? And there's reasons why you should, but in order to meet that, I decided to launch a series of online leasing courses that will be multi-week courses, but they will only require 2 hours of work a week. So it'll be an hour of pre-recorded video and then an hour of Zoom where we'll have a case study and have an interactive conversation. So if the topic that week was work letters, we'll have a pretend hypothetical situation regarding construction and tenant improvements. Based on the materials that were previously provided. We'll all have a discussion live in Zoom on that topic and how would we resolve it, and give you some skills for when you go out in the real world and have to negotiate these issues and understand the tenant's perspective, landlord's perspective. So I'm hoping to launch that soon. Stay tuned for more details on that.
So Joanne, real quickly, how could somebody reach you if they want to find out more about this?
Sure. So you can email me at jw@jleasinglaw.com, or if you just Google Joanne Woodson Law Offices, you'll find my website, and that will have information as well.
Well, thanks. This is great. Please, you're welcome to stay for the remaining, 18 minutes of our presentation today in China.
Well, thanks for letting me talk.
Thank you, Joanne.
Okay, good. So let's see what else we're going to talk about today. We have a couple more cases. This one is Dow versus Honey Lake. I put this one up here because I thought it was so interesting, which is, what does the word "or" mean in the context of a commercially drafted document? And, the particular case here happens to involve water rights. And there was someone who had senior water rights and someone who had junior water rights. But it all boiled down to, what does this 2-letter word mean in the context of this very complex water right agreement, or water decree, as it was called? And, is "or" in the disjunctive? Is it inclusive? Is it exclusive? And I'm just going to briefly read to you what I thought was an interesting part of this opinion. Courts must frequently ascertain the meaning of words or phrases in writing. Of course, semantics matter. The use of the word "or" often presents an especially treacherous lexical conundrum due to its high risk of ambiguity. Every use of "and" or as a conjunctive involves some risk of ambiguity. And it goes on to talk about a resource book, and it says, in words and phrases, the word "and" takes up 61 pages of digested cases, and the word "or" takes up another 84 pages of digested cases. So who would think that these 2 letters, would be, so troublesome in the legal lexicon? And it kind of boiled down to, is, what was the intent of the parties? How is this word "or" used in context? And that's all I wanted to say. I thought it was an interesting case because, all of you who are transactional attorneys, you're writing documents, you probably have that word somewhere in your document. And is it clear or is it not? So I'll leave it to Ashley and Tom to opine.
So I was confused in it. So they said that the "or" was inclusive or not inclusive?
In this case, they said it was inclusive, that the senior water rights holder had the right to both divert the water for use and to store it in some kind of storage facility.
Gotcha.
I thought the decision makes sense, but yeah, as a litigator, these issues come up, and you're kind of stuck with the quality of the drafting of the agreement. I'd love to hear Joanne's take on this subject, because you protect yourself on the front end, right? And that's the best strategy as opposed to dealing with it in court.
Yeah, I mean, in leasing, the Advanced Leasing Institute that I mentioned that I go to at Georgetown, there's usually one session on some little tiny word and how it can really cause enormous problems. And this year, the word was "shall." Now, I'm very fond of "shall," and I use it all the time. And after 1 hour being pounded over the head of why that's bad, I then understood how it could be interpreted as not being an imperative. I read "shall" as "you must do this," in which case they say, well, then use the word "must." So these words, and especially in the heat of a transaction and you're trying to draft really fast, everyone thinks they know what they mean, and then they can come back and really haunt you. So yeah, take time, think about what you're doing. Clients are paying you a lot of money to think. That's what I say to people.
That's what keeps me up at night as a transactional attorney.
Well, it's nice to know that, in words and phrases, there's 141 pages of cases discussing this, to give you something to look at on one of those quiet nights, right? And what I like about this is it's not just for those, that went for all that additional education through law school, right? Conjunctions. Anybody remember this?
I can't hear it, Neil. Neil, we can't hear it at all.
Oh, you can't hear it. It was from Schoolhouse Rock. It was conjunction and junction.
Oh, bummer.
Sorry.
I do remember Schoolhouse Rock though. Yeah.
Schoolhouse Rock was a little after me, but I know it. Okay, so let's do our last case real quickly. We'll get to our announcements. Tom, I'm sure, has a few words to say about the Crocker Symposium. So again, this I thought was an interesting case. Try to give you some things that are recent. I first saw the title of this case, and it was not at all what I expected. I'm saying Alliance for Responsible Planning, and I was thinking this is a women's issue case, and it's really responsible planning for traffic planning. So versus Taylor and the County of El Dorado, kind of an interesting case. Basically, was deals with takings in California, and I have to tell you, from what I've seen with takings cases, it's really tough to be a property owner and to try to be successful in a takings case. But not here. Here the owner, the property owner, the developer was successful challenging Measure E, which was adopted in El Dorado County, that basically said what? It said, hey, if you have a project of 5 or more parcels that worsens traffic, right? You're not going to get approval for that development unless the infrastructure is totally built out to allow for the increased traffic, not just for maybe your 5, your 10, your 100 unit development, but for all of the problems that might arise. And the developer said, well, wait a minute, that's not fair. If I'm putting 5 more cars on the road, why do I have to build an entire road that's going to take, hundreds of thousands of, cars a day? That's not right. It's not proportional to the damage that my development is causing. And so what happens, they brought a writ of mandate challenging Measure E, and the court said, you're right. The 2 most famous cases in California here are Nolan and Dolan, and the full sites are in the case. And the court says, there's got to be a rough proportionality between the harm that's being caused and the exaction that the city or the government entity is imposing on the property owner. And look at this last line here. Here they plainly cast a wider net than the harm resulting from an individual project. It's like I said, I've seen a lot of cases that go against the person trying to claim a taking, but this was just too much. The court said you can't require this much. Listen, there was a legitimate problem that was trying to be addressed, which is cities or counties were collecting money and then never building out the infrastructure, right? And so a Measure E was designed to kind of prevent that problem from happening, but Measure E, at least according to this court, went too far. What say you, our other speakers today?
I concur with the decision. I just think there was an overreach here, and so yeah, it's challenging being on the developer owner side, but in this instance, I think the owner did a good job advocating with the burden they would impose on the roads would be versus what was being extracted. So I'm just echoing what you said, but this is one where I think the court, the facts were such that the court could side that direction for sure.
Okay, so let's just kind of move on here. I see I got a notice that my screen is about to go blank, so if it does, I'll turn it right back on. Apologize. So here's what's coming up, with the real property law section. We got some, live webinars coming up, a couple in June, a couple in July I wanted to mention. I was just actually on a meeting dealing with partition in California and a law to try to address partition cases where there is a significant number of family members who own the property. I don't know if anything's going to happen in California, but it made me think of this partition case. Sorry about that, everybody. A construction law update, public contract, and then interesting, how to effectively and ethically online market. And then real property law section has a whole summer cannabis series. It was supposed to be a live lecture series last year in association with the real property spring conference. Of course, there was no live conferences last year. It was decided to do it virtually this year. It's broken out into 3 different segments, all having some aspect of dealing with cannabis. And this is a joint effort between the real property section and you can see the other sections at the California Lawyers Association, environmental, intellectual property, real property, that's me, I'm doing that section. Hope you all join us. Criminal, public law, and labor and employment. So really a far reach if someone is interested in learning about how cannabis impacts not just real estate, but a lot of different areas. Tom, we're going to get to your Crocker. Just want to remind everybody, if you hear some webinars that you may have missed, you want to come back. And hopefully, Joanne, your Woman in Leasing series will also be up in a replay someday. So that'll be announced, sometime later. It just ended, I think yesterday was the last one. Is that right?
No, last Thursday.
Last Thursday. Okay, so it'll take some time for that to enter into the replay series. Okay, so Tom, tell us a little bit about the Crocker Symposium coming up in September.
Sure, I'd be happy to, Neil. Before I even get to that, for those of you who haven't seen Joanne's Women in Leasing series, you should keep checking online to see the new classes come up. You need to check that out. The cannabis series looks fantastic too, by the way. So I'm looking forward to seeing that. I'm co-chairing the Crocker Symposium in partnership with the LA County Bar Association. I have a co-chair counterpart at the LA County Bar, Teresa Hillary. We're really excited about putting on the program. It's on September 9th. This is our 3rd year running in partnership with the LA County Bar. Traditionally, it's been 3 classes that start in the early afternoon, an hour and 15 minutes each. One focused on development issues, one focused on leasing, one focused on finance, followed by a reception, which is virtual. It was actually quite enjoyable last year, so we had a successful virtual reception as well. We're going to be on Zoom this year as well, so we'll be virtual. This year we're going to be focusing on the housing shortage, as well as in the commercial leasing field. We're going to be focusing on a go-forward look at what's happening in leasing as a response to COVID and what the market is looking like and how the landlords are responding to market conditions. Then new developments in financing as well in the finance course. So keep a lookout for future announcements related to the panel details and the program details, and hoping to see everyone there. So thanks again, Neil, for allowing me to join as well as a guest host this week. It was really terrific.
Hey, absolutely. Hey, Ashley, I've got a couple of, a question and a comment, I guess, for you. I see one of the replays is on residential purchases and sales. I couldn't put the whole title in there, but I believe that was your webinar, right? With some others?
Yeah, I did that with Elva Harding and Renat Ehrlich and Jose Mendoza, and it was talking about pitfalls in residential purchases and sales and handling for sale by owner situations.
Yeah, so it was a great webinar. I got to hear most of it. Couldn't stay for the whole thing, but that was a really great webinar. Matter of fact, I think Jose, who participated with that one, I think he's also a participant in the first replay, the one on June 22nd, when adversaries are friends. And it was really kind of an interesting take, right? Because, for example, we're very collegial here at the Real Property Law section. I have to say, I think just about everybody likes just about everybody else on the XCOM and with the advisors. But when you're in court, you're not there, right, as friends, right? You're there as adversaries. So it was really kind of an interesting take on how that relationship, how that dynamic affects people in different parts of their professional lives. So something interesting there. And my question for you, Ashley, is in that kind of right top-hand corner, sort of oranges box. I thought you're somewhat involved in these sponsorships for these various real property section programs. So there's sponsorship opportunities for our e-news, which is our monthly electronic newsletter, for the journal, our quarterly journal, which has great substantive content, law review type articles, for webinars that we put on, for our virtual events like the cannabis series. How come there's no sponsorship opportunity for What's Up With Us? Like, there's plenty of white space, in these slides we have where somebody could say, brought to you by, so it would be kind of nice, I'm just curious how come we are left out.
Yeah, you're right, Neil. That's an oversight on my part. We will fix that immediately and add that in.
Okay. Well, thanks a lot, Ashley. We'll look forward to that. See if one of our reliable listeners may want to, get their name up, on these slides. And that's about it. So, hey, we're right at the end of our time. Thanks again for joining us. Ashley is a regular with me and Frantz. Tom, this is your second guest host. So it's such a pleasure to have you. Joanne, it was so nice to hear about what you're doing. And hey, listen, now we know for sure, right? We've got a commercial leasing lawyer in Nevada, right?
That's right.
Right?
And in England.
And England, and a solicitor, I guess. That's the right term.
That is the term.
So, always good for everybody to know about. We'll be back next month, Thursday, July 15th at 12:30. See you later, everybody. Oh, real quick, we do have a couple minutes. I did not see anything in the chat. If anyone is still on, you have a question for us, you are welcome to have posted it at any time during our hour. I don't see anything. If you want to throw something in right now, right before we get off, you're welcome to do so. We'll hang on just for another minute, just in case. If not, we hope to see you again next month. All right, that looks like that's it. Bye, everybody. Thank you.
Thank you.
Bye-bye.